Everyone knew him as the Microsoft billionaire who changed the world. But when Bill Gates stood up in federal court that day, he was about to reveal a secret he had kept hidden since his Harvard days. Not just technological genius, but deep antitrust law expertise, years of studying monopoly regulations and constitutional business protections, mastery of competition law frameworks that would make Justice Department lawyers jealous. Federal Judge Patricia Williams was dismissing him as just another tech CEO trying to escape accountability, completely unaware that standing before her was someone who understood antitrust law better than the government's own prosecutors. Gates' first legal argument alone would completely transform the courtroom dynamics and leave everyone speechless. "Your Honor," said Gates, his voice carrying the same precision that had built a global empire, "may I speak to you about the Sherman Antitrust Act's relationship to innovation and how current enforcement actually stifles the technological progress Congress intended to protect? What happened next in that Washington, D.C. courthouse would revolutionize both antitrust law and our understanding of constitutional technology regulation forever." Before diving into this extraordinary fictional legal confrontation, don't forget to like this video and subscribe to our channel for more stories of unexpected legal brilliance that will blow your mind. Judge Williams' world, Government Antitrust Authority. Federal Judge Patricia Williams represented the aggressive new wave of tech regulation. At 58, she had built her reputation on breaking up what she viewed as dangerous technology monopolies that threatened American competition. A Yale law graduate with extensive experience in antitrust enforcement, Williams embodied the government's determination to rein in big tech's power. Her judicial philosophy emphasized protecting consumers from corporate monopolization, viewing tech giants as modern-day robber barons who used innovation claims to justify anti-competitive practices. Williams particularly believed that tech executives used constitutional arguments to mask their monopolistic behavior. That day, her assumptions about Bill Gates were predictable. Yes, Gates had built Microsoft into a global powerhouse, but in Williams's view, he was simply another monopolist using legal theatrics to avoid legitimate antitrust enforcement. She had no idea she was about to face a constitutional scholar who understood competition law better than most federal prosecutors. Gates' hidden journey, from code to constitutional law. The world knew Bill Gates through his technological achievements in philanthropic work. From founding Microsoft to revolutionizing personal computing, from building a $100+ billion fortune to dedicating his life to global health initiatives, his impact on human civilization was undeniable. But what the public didn't know was that Gates's early experiences with antitrust investigations had sparked an intensive 20-year study of competition law and constitutional business principles. Starting in 1998 during Microsoft's first major antitrust case, Gates had begun serious study of Sherman Act jurisprudence and constitutional commerce theory. "I realized that technology innovation operates within legal frameworks that most engineers never understand," he had confided to his wife Melinda during one of their strategy discussions. "If we're going to build companies that serve humanity, I need to understand the constitutional principles that should govern business competition." Working with antitrust professors from Harvard and Stanford, Gates spent his post-Microsoft years studying Supreme Court competition precedents, constitutional commerce clause interpretation, and the intersection of innovation with antitrust law. He completed advanced coursework in constitutional law, competition policy, and the legal foundations that govern technological progress. By 2023, when this case brought him to federal court, Gates wasn't just defending Microsoft's legacy. He was also a genuinely educated advocate for constitutional innovation rights, with deep expertise in the antitrust law that governed technological competition. The case, Innovation versus Government Control. The federal case that brought Bill Gates before Judge Williams represented one of the most significant technology law challenges in decades. Gates v. Federal Trade Commission challenged the government's new innovation monopoly regulations as violations of both constitutional due process and First Amendment protections for technological expression. The FTC's new regulations required technology companies to obtain government approval before launching products that might dominate markets through innovation advantage. The agency argued that technological superiority created unfair competition that antitrust law should prevent. For Williams, this case represented an opportunity to establish that innovation itself could constitute illegal monopolization when it gave companies too much market power. For Gates, the case was about fundamental constitutional principles, whether the government could constitutionally prevent technological innovation, and whether antitrust law was being weaponized to punish success rather than protect competition. The courtroom confrontation. The modern courtroom was packed with technology lawyers, antitrust scholars, and Silicon Valley executives. At the defendant's table sat Bill Gates, dressed in a conservative Navy suit, flanked by constitutional law experts, though Gates had insisted on presenting key arguments himself. At the government's table, the FTC had assembled their top antitrust prosecutors, confident this would establish important precedents for controlling big tech innovation. First contact, the dismissive challenge. Mr. Gates, Judge Williams began, her voice carrying prosecutorial authority, this court recognizes your technological accomplishments. However, antitrust law exists to protect competition from exactly the kind of market domination your innovations have created. Are you prepared to explain why innovation should be exempt from legitimate antitrust enforcement? The question was designed to highlight what Williams saw as tech industry arrogance toward legitimate government regulation. Gates stood deliberately, his posture respectful but confident. Your Honor, I appreciate your concern about market competition. However, I'd like to address that concern by discussing the Supreme Court's analysis in Verizon Communications v. Law Offices of Curtis V. Trinco, and how antitrust law must distinguish between competition-enhancing innovation and anti-competitive conduct. A surprised murmur went through the courtroom. This wasn't the typical tech CEO deflection Williams had expected. The Sherman Antitrust Act, Gates continued, prohibits restraints of trade and monopolization, but the Supreme Court has consistently held that achieving monopoly through superior products, business acumen, or historical accident is not illegal. What violates antitrust law is the willful acquisition or maintenance of monopoly power through anti-competitive conduct. Williams's expression shifted slightly. The response demonstrated actual understanding of antitrust doctrine, not just business talking points. Testing constitutional waters. Mr. Gates, Williams continued, her tone becoming more serious, citing antitrust precedent is one thing. Understanding how modern courts balance innovation incentives against competition protection is quite another. How do you address the argument that technological dominance itself harms competitive markets? This was designed to test whether Gates understood the sophisticated balance between innovation and competition that defined modern antitrust law. Gates nodded confidently. Your Honor, that argument fundamentally misunderstands both antitrust law and constitutional principles governing technological progress. The Supreme Court's decision in Illinois Toolworks Inc. v. Independent Inc. established that market power alone does not create antitrust liability. What matters is how that power is acquired and exercised. Williams leaned forward, her interest piqued. Continue. The FTC's regulations violate this fundamental principle, Gates proceeded, because they punish innovation itself rather than anti-competitive conduct. When government prevents technological advancement because it might create market advantages, it violates both antitrust law's purpose and constitutional protections for innovative expression. The revelation. Gates' antitrust expertise. Mr. Gates, Williams said, her tone markedly different from her initial dismissiveness, your antitrust analysis demonstrates considerable legal sophistication. Where did you develop this expertise in competition law? Gates's response revealed years of preparation. Your Honor, I've spent over 20 years studying antitrust law and constitutional innovation principles, initially through Harvard Law's executive program, later through private study with antitrust scholars specializing in technology competition and constitutional commerce. I've worked directly with Professor Einar L. Hauge at Harvard on antitrust innovation theory, studied under Professor Tim Wu at Columbia on technology competition policy, and completed advanced coursework focusing specifically on the intersection of technological innovation, market competition, and constitutional business rights. The courtroom buzzed with surprise. Williams herself looked genuinely taken aback. Constitutional framework. Analysis. Williams, now taking Gates seriously, tested his deepest understanding. Mr. Gates, you're essentially arguing that innovation itself receives constitutional protection from antitrust enforcement. How do you reconcile innovation incentives with legitimate government interests in preventing monopolization? This question went to the heart of modern constitutional commerce law. Gates's answer demonstrated sophisticated constitutional understanding. Your Honor, there's a crucial distinction between protecting innovation, which serves constitutional purposes, and preventing anti-competitive conduct, which antitrust law legitimately prohibits. He organized his constitutional argument carefully. The Constitution's patent and copyright clause specifically incentivizes innovation by granting temporary monopolies to inventors. This demonstrates that the framers understood innovation benefits society even when it creates market advantages. Williams was fully engaged now. You're arguing that antitrust enforcement cannot target innovation itself. I'm arguing that when antitrust enforcement punishes technological superiority achieved through legal means, it violates constitutional principles that protect innovation as beneficial to society, Gates responded. The Supreme Court's decision in Spectrum Sports Inc. v. McQuillan confirms that antitrust liability requires specific anti-competitive conduct, not just market success. The precedent challenge. Gates then presented his most sophisticated argument. Moreover, Your Honor, we have direct precedent protecting innovation from government restriction. The Supreme Court's decision in Sorrell v. IMS Health Inc. held that regulations targeting commercially valuable information receive heightened constitutional scrutiny, even when justified by competition concerns. Williams was taking careful notes. How does Sorrell apply to technology innovation? Sorrell's principle applies directly to the FTC's regulations, Gates replied. When government restricts technological innovation because of its commercial success, it engages in content-based regulation of innovative expression that receives First Amendment protection. Gates concluded with his strongest constitutional argument. Innovation drives economic progress and human welfare. When antitrust law is used to prevent rather than protect innovation, it violates both constitutional commerce principles and the fundamental purpose of competition law itself. Williams's constitutional recognition. The change in Judge Williams was evident to everyone present. Mr. Gates, your constitutional arguments have been exceptionally sophisticated. You've presented antitrust analysis that merits serious judicial consideration. Thank you, Your Honor. This case isn't about avoiding legitimate antitrust enforcement. It's about ensuring that competition law serves its constitutional purpose of protecting rather than punishing the innovation that benefits society. The landmark decision. 2 weeks later, Judge Williams issued a groundbreaking 35-page decision that revolutionized technology antitrust law. The ruling found that the FTC's innovation restrictions violated constitutional protections for technological expression and exceeded legitimate antitrust authority. Williams's opinion adopted Gates's constitutional framework, creating new precedent protecting innovation from government overreach while preserving legitimate antitrust enforcement against anti-competitive conduct. The decision included an extraordinary acknowledgement. This case demonstrates that constitutional wisdom about innovation and competition can emerge from those who have lived the practical effects of antitrust law. Mr. Gates's analysis has meaningfully contributed to this court's understanding of constitutional protection for technological progress, industry, and constitutional impact. The Gates v. FTC decision immediately changed federal technology policy and sparked national conversation about innovation rights and government regulation. Constitutional scholars praised it as a landmark victory for technological freedom and innovation protection. Law schools began incorporating Gates's constitutional arguments into their antitrust and technology law curricula. The case became required reading for understanding the intersection of innovation, competition, and constitutional law. For the technology industry, the decision established crucial precedents protecting innovation while preserving legitimate antitrust enforcement against truly anti-competitive practices. Long-term legacy. The constitutional precedents established in Gates v. FTC influenced both antitrust law and innovation policy for years afterward. The decision's framework for protecting technological progress became a model for courts addressing innovation and constitutional law. Most importantly, the case demonstrated that constitutional expertise could emerge from business experience with regulation, and that meaningful innovation arguments often came from those who understood both technological progress and constitutional principles. Bill Gates had proven that defending innovation requires combining technological understanding with rigorous constitutional scholarship, and that protecting technological progress demands the same constitutional courage necessary to defend all fundamental rights. If you found this incredible fictional story of technological constitutional courage inspiring, smash that like button and subscribe for more amazing tales of unexpected legal genius. Ring that notification bell so you never miss these extraordinary fictional stories of how innovation and constitutional knowledge can protect technological freedom. What did you think of Gates's constitutional expertise? Drop your thoughts in the comments below. Important note: this is completely fictional entertainment. Any resemblance to real events or persons is purely coincidental.